We remember to record this one. Welcome, folks. Welcome. We'll start this thing up at 10 o'clock on the dot. That's our goal. Hope everyone's having a good Friday so far. One minute to go, and then we'll start up. All right, I've got 10 o'clock on my. I've got 10 o'clock, so let's get this show on the road. My name's Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. I helped draft the forms, so we're going to talk about one of the specialized forms. Specifically today, we're going to be talking about letters of intent. It's worth noting the letter of intent is kind of a broad concept, and this is just the Oregon Realtors version of it. So we'll talk about kind of what that means. But if you've experienced letters of intent in the past, this might be different. So as a baseline, a letter of intent, we sometimes you'll hear LOI. It's used to identify basic terms in a party's agreement. It's essentially something that says we're gonna figure the rest out later, but we're gonna figure out the main terms now. So it's used when you have a transaction that's going along where you expect to have a further amount of detail added in the future, but the parties are really only concerned about some very specific details, usually purchase price, closing date, in some cases, earnest money, that kind of thing. And so it's used essentially as a fast track of the terms that parties want to know to ensure that you get a deal essentially kind of on the right track before you get too far down the road on kind of the rabbit holes and the pigeonholes of detail. Letters of intent are not meant to be binding agreements. The norm, or at least kind of the broad standard for a letter of intent, is that it will specifically say this is not a binding agreement. You may run into occasional binding letters of intent that have something along the lines of like a truly binding. It's basically just a precursor, like simple agreement to agree in the future, and you're bound to agree in the future. That can be done. You'll see lawyers doing that more often. In the real estate world, what you typically will end up seeing is a letter of intent is a more simplified, non-binding negotiation tool. You can have something that's a truly binding letter of intent. At that point, it's just a contract, or a letter of intent that is essentially non-binding. Depending on which direction you go, it changes the way that the form is written for whatever you're using it for. You can also have something that's kind of a mixture in between. The Oregon Realtors Forms version of the letter of intent is kind of that middle zone. It has binding terms and it has non-binding terms. Most of our letter of intent is non-binding terms. That means if you sign the letter of intent, you are not technically bound to carry forth whatever you've written down in the non-binding terms section. We'll get more in depth on that. But there are elements of this letter of intent that will stay binding for the entirety of the transaction. In most cases, this is going to be confidentiality and non-discrimination. We'll get to that, and we'll go kind of piece by piece on the letter of intent. So it is somewhere in between hyper complicated and hyper binding and simple negotiation tool that is absolutely non-binding. It's worth pointing out how the law of these things works. There is some case law in Oregon that relates to letters of intent and how they operate. The first one is Wagner versus Rainier Manufacturing Company from 1962. This is a pretty old case. Letters of intent have been around for a long time. In that case, the court found that if there is a letter of intent that has open and clear intent to not bind the parties, the courts won't enforce it as a binding agreement. This is where we talk about most letters of intent are non-binding. This is essentially why. If the letter of intent says this is not binding, you really aren't going to be able to argue that it is meant to be binding. You can sometimes make a showing of that, but it's very difficult. Usually what you have to have is a very clear intent to actually be bound. So if there is some kind of an intent not to be bound where the parties are in some way manifesting that proof, it's not a binding letter of intent. It doesn't have to be non-binding in writing. That's one thing that's worth noting. If the parties have an agreement on a letter of intent and then they start talking about it and they change the terms before they actually go to their final negotiation over an offer and acceptance, the courts won't enforce the original letter of intent terms because the parties have changed their mind throughout the process, which then implies to the courts through the actions of the parties that you did not have an intent to be bound. There was no and the actions of the parties creates an open and clear intent to be not bound, to be unbound by the terms of the letter of intent. So as a baseline, the default stance, if a letter of intent says it's not binding, it's not binding. You can't make it binding at that point. If there's a provision of a letter of intent that says it's supposed to be binding, the courts will enforce that if it is sufficiently definite. Usually, this is from Logan versus D.W. Sivers Company. This is a 2007 case, so we get kind of a range over the last 50 or so years, 60 years. You have quite a bit of movement on how the law works on this. This is the most recent version of it. And in this case, they basically just described it and said, look, if you've got a term that says we are going to be bound to this, even though the letter of intent is non-binding, this provision is binding, they will enforce that provision and it will hold its bindingness throughout the contract. Now, the courts require that this binding provision, so usually non-solicitation or confidentiality, it has to be sufficiently definite. That term is really not super well defined, but the cleanest way to understand it is that means if it's going to be, if you have a letter of intent that is going to be binding, the definiteness of it needs to be in writing in the letter of intent or in an amendment to that letter of intent. It isn't something where you can imply it through the actions of the parties. So if it's in writing, you have to put it in writing to make a letter of intent binding. You don't have to put it in writing to make it non-binding, and that applies kind of to individual provisions throughout the letter of intent. So if a specific provision says this is binding, that specific provision will be seen as binding and the rest will be non-binding. And so it's kind of a grab bag in how we interpret the form. The third law that's really applicable on letters of intent is Lost Springs Development Corporation Incorporated, the company, versus Whitley. This one was talking about a letter of intent, and it said, look, if you've got a letter of intent that you sign between the actual parties, but you never get around to signing a sales contract, the courts won't enforce the letter of intent as a sales contract. It's completely different. In that case, there was essentially two parties in 91 in this case where they had this back and forth letter of intent that they'd signed and agreed to some of the terms on it. And then back and forth, they were going with their various negotiations, and the buyer kept on sending offers over to the seller, and the seller never signed the end of the offers. And then suddenly towards the end of the process, the buyer said, well, we have this letter of intent. That's just our terms now, and you signed it earlier. That's not how it works. The letter of intent does not form a binding contract. That requires an actual sales agreement. So the courts, since 91 at least, the courts in Oregon have said if you have a letter of intent, it's not a sales agreement. It doesn't operate as a sales agreement. It is a letter of intent. It's its own separate concept and separate use case. So if you have a non-binding letter of intent that establishes terms of a contract, but you don't sign the actual sales contract, you don't eventually write that offer and get this thing put on paper as a sales contract, it doesn't work the way you think it does. And so what that essentially means is if you're going to have a sale or a land sale contract, you got to put it in writing. You got to put it in an actual offer itself. The letter of intent will not substitute for that land sale contract or that purchase offer. So there was stuff earlier than that before the Wagner case that essentially said that the default position for a letter of intent is that it just starts negotiations. It's not binding legal documents. But since 91, that's been pretty clear. A letter of intent is not a binding document. You can have provisions within it that are binding, but the letter of intent in its base form is not binding. Now, open question, if you have a letter of intent that has sales agreement terms like the purchase price and the closing date and things like that, and it also says we very much intend for these provisions to be binding, we definitely mean to purchase at that time, theoretically, that's no longer considered a letter of intent. That's actually considered a sales agreement, even if it says letter of intent at the header, because at that point you're using it to transact the sale, not to transact the negotiations. So if you do have a letter of intent that you make fully binding to cover all the terms that you would normally put in a sales agreement, you're outside the law of letters of intent and you're inside the laws of sales agreements, and you might have some serious problems that come up at that point because your letter of intent isn't operating as an earnest money receipt necessarily, and you might have some problems that arise from that. So letters of intent, use them for negotiations, don't use them for sales agreement substitutes. In the letter of intent, there are kind of two broad ways that it works, at least in the Oregon Realtors forms. We have non-binding provisions, this is most of the form, and binding provisions. In the non-binding provisions section, we read it out. Parties to this letter of intent agree and acknowledge that all non-binding provisions reflect only general understandings of matters described therein, and are not intended to constitute a complete statement of or legally binding or enforceable obligation on the part of the parties. Neither party shall have any liability to the other with respect to the non-binding provisions until a real estate purchase and sale agreement is signed and delivered by and between the parties. If an agreement is not prepared, signed, or delivered for any reason, neither party to this LOI shall have any liability to the other party arising from the non-binding provisions of this LOI. Basically, we put it in as clear language as we possibly can. This is not a sales agreement. It is meant to reflect general understandings, broad understandings of what the terms are going to look like in the end, but no one's going to get in trouble if the final sales agreement has different terms and it is changed from the letter of intent. Now, we'll get to it in this training. What's the point of a letter of intent if it can change? Good question. We'll talk about it. But what the non-binding provisions exist as is essentially just a nice summary page of all the stuff you sort of want the other party to agree with you on. Now, the binding provisions, these are different. Binding provisions will constitute legally binding and enforceable agreements of the buyer and seller. The buyer and seller are advised to seek independent legal counsel to further interpret and understand their rights under this LOI. So, non-binding provisions, you could have a lawyer look at them. That's basically just someone giving you sales advice on whether or not it's a good purchase or a bad purchase, or if you can close in that time frame. The binding provisions, if you really want to know what a confidentiality provision means, talk to a lawyer about it. This is one thing that's worth noting. As a real estate licensee, your license grants you the ability to do certain things, including professional real estate activity. This is ORS 696-010-17 is the professional real estate activity pocket or definition. If you look at that, it's got a list of, I think it's 12 or 14 different definitions of things that you can do with your real estate license, what professional real estate activity is. And it's got stuff like helping somebody negotiate a purchase and sale agreement, helping somebody do a comparative market analysis, all those fun things that you do as a realtor. It does not, however, include opining on legal rights or legal risks that are involved in a transaction. Under ORS 9 point, I believe it's 160, that's the definition section for practice of law. In the state of Oregon, practice of law basically says if you're helping somebody with legal rights, that is practice of law. Now, there's carve-outs which say if you're a real estate licensee doing what a real estate licensee can do, not practice of law. But the practice of law question comes down to what a professional real estate activity is, and telling someone how to interpret binding provisions of a letter of intent, that's probably practice of law. It's more likely practice of law than not. It's something that would have to be enforced by the Oregon Bar Association. I don't believe they have enforced anything along those lines in a long time, to my knowledge. But be aware, you don't want to tell somebody what a letter of intent binding provision means, or say like, oh, that confidentiality provision, you can ignore that. Nobody ever worries about that. Now you've put yourself on the line for potentially practicing law in a way you don't want to. So don't give opinions on what the letter of intent binding provisions mean. You can give comparative market analyses and help somebody with negotiations on the non-binding provisions. Our letter of intent starts, the first chunk of it, the first 6 sections are not technically even in the binding or the non-binding provisions. It's just data. It's information about the transaction. It starts off with the letter of intent is setting forth non-binding and binding provisions below. That's what a letter of intent does. We just say it. Here are the parties to the LOI, the various buyers, the various sellers. Here are the names of the brokers for this one, the seller's agent, the buyer's agent. Fit as much as you can in there if you can. We understand that this isn't a lot of space, so if you got a team with like 9 different people on it, that may not be sufficient. In this case, you can write in that section C addendum A and just attach an addendum that says buyer's agent in section 3 also includes John Smith, John Smith 2, John Smith the third, and so on and so forth until you've described everybody on your team who is like a broker or real estate agent under Oregon law. You then have the property description. This is the property's address and the county it's in. Now, note in this one, we don't give you the space for like, if property address is insufficient, put in the legal description, because this is a letter of intent. The parties probably know what property they're talking about, and if they don't, then you should have some more detail in there so they really understand it. But it's not something where you're going to get in trouble if you don't have a legal description on a letter of intent. The parties are just negotiating. It's a tool. So you don't need as much depth with the descriptions. Now, if that property address, if I put down 123 Main Street and you have literally no idea what property I'm talking about, put in more description. Say see general addendum B and put in the legal description so that parties can find this plot of land that you're dealing with. But broadly speaking, this is just the property address section here in section 4. This is just to let the parties know here's where it is. If you Google it, this is what's going to pop up on Google Maps. That's the property we're looking at. And just so that you have something to kind of like set and orient the transaction based upon. Section 5, subsection 5, this one's somewhat important because the letter of intent can be used for a various wide array of things. We do have the property type definition, which basically says for what we're dealing with right now, it's residential, it's commercial, it's a manufactured home, it's an agricultural piece of land, it's vacant land. You won't typically use this for manufactured homes or floating homes. It's possible you would, but you wouldn't use it often. You're probably not going to use one of these very often for vacant land unless it's a huge plot of land that's got a bunch of forest on it and stuff like that has to get figured out. More often than not, this will be commercial, agricultural, and sometimes residential, but it's typically commercial and ag is what's going to use this. So what you do in this section is you literally just check a box that says what type of property you're dealing with. This then tells you what provisions of the LOI are relevant or irrelevant. The reason for that is at times we'll have provisions that are important in a letter of intent, but they're unimportant for various types of properties. For example, grazing, timber, crop, mineral rights. That's really only relevant in an agricultural land purchase and sale agreement. If you're dealing with ag land, a ranch, silver load of some sort, something along those lines, then the question then is the seller going to retain those rights to kind of utilize the property for commercial agriculture, to sharecrop the land after you've sold it, or are they not going to retain those rights and it all transfers to the buyer? That's relevant information that you're definitely going to want to know on your letter of intent. Whether the buyer can actually build, start farming the land after they buy it is really important when you're buying a farm. So you do want to specify this stuff, but for every piece of property that's not agricultural, this provision is irrelevant. So what you do then is you look at the little subscript. If it's got a tiny 4, then that means you're dealing with agricultural land. If it's got a tiny 5, that's vacant land. Tiny 1 is residential, tiny 2 is commercial, tiny 3 is manufactured floating home. And so that subscript is going to tell you what you're dealing with, and it'll kind of define what provisions are relevant. If it doesn't have your little number on it, you don't have to worry about it. Or if it's got a number on it that says 2, 3, 4, that kind of thing, at that point, that's telling you this is a special provision that only applies to this kind of property. So if it has a little subscript 2, and you're not dealing with commercial land, you don't have to worry about that section. The last provision there is counting time. Counting time is it's a general provision that we have in our sales agreements. It essentially just says how time operates in these contracts. So when we say you have 5 days to do 5 days counts from the day after mutual acceptance of the contract or the triggering event. So if you have 5 days to review the title report, well, title report gets delivered. Then the next day starts the first day of that 5-day period, and that 5-day period will end, depending on if it's a business day or a calendar day, at a specific time frame. So this is where we kind of define timelines because the LOI will have some timelines in it, and you do want to have that established. Now, it's not described as a non-binding provision or even a binding provision. It's just informational, and it's kind of like the how the contract works provision. So treat it as a binding provision, but there's no real binding to it. It's more like an advisory that tells you how to read the contract. Once you actually get into the binding provisions or the non-binding provisions, so the contract, it's general information, non-binding provisions, and the final section is binding provisions. The non-binding provisions starts out with this section 7, basic transaction. Subject to any changes to the provisions that may be negotiated by the parties in this agreement, the buyer would purchase the property from the seller upon the terms and provisions in this LOI. The agreement would contain the usual and customary conditions and terms found in an Oregon Realtors form purchase and sale agreement and any addendums, exhibits, or additions thereto. It essentially says how the form is supposed to be used. It establishes that the parties are going to agree to major terms, and we'll flesh the rest of it out. We'll put additional detail on as we go. Now note, all of the language in the non-binding provisions section is prospective. It's about subsequent agreements. So it's would contain proposed terms that will be there in the future. We may agree to. It's all stuff that has not happened yet and is technically still uncertain. It's essentially saying, looking out into the distance, if we look a couple days down the road, this is what the agreement might look like. If you like it, I'll write that offer. If you don't like it, we're not even going to go to that stage. The presupposition is that the parties will be using Oregon Realtors forms, so be aware. This is kind of built into the letter of intent. We are assuming if you're using the Oregon Realtors letter of intent, you're going to be using the Oregon Realtors purchase and sale agreements, because this letter of intent does reference kind of internally documents from the Oregon Realtors purchase and sale agreement libraries. So for example, when we talk about, for instance, the environmental review, we have a section in our commercial transaction that talks about environmental review. We have timelines on those things that are relevant to that. When we talk about due diligence, that's the Oregon Realtors version of an inspection period. It's the due diligence period. It is no longer requiring an inspection. It's just diligence. Look into all the stuff. See if the zoning works for you, that kind of thing. That's how this letter of intent is based, is using the language and terms of the Oregon Realtors library. You can theoretically use it for something other library, for a different form library, and use this as the letter of intent. If you just really like this letter of intent after doing this training and you think it's just wonderful, then you can. It's just going to be sort of a round peg in a square hole. It might not fit exactly what you need, and that might not be as useful as you want it to be. And so the LOI might be kind of less effective or less useful as a negotiation tool if you're not using it on the Oregon Realtors library. It's been designed to be internally compatible with our library. It's not designed to be internally compatible with other libraries. At some point in the future, that might be something that can be done, but we haven't had any interest from the other parties or libraries to do that sort of thing. So the meat of the non-binding provisions, the first part of it, it literally just covers a bunch of the proposed financial terms: who gets paid, how they get paid, when they get paid, and what's the proof going to look like. So a commission, we start off with the proposed real estate commission. Hey, heads up, a commission would be paid by buyer or seller or some other arrangement. If the property is not listed on an MLS, the commission is going to be X amount of the price, then it'll be paid to the broker. This in the LOI is not technically an antitrust violation because the parties are allowed to negotiate it amongst themselves. It's not something that is imposed from the top. It is something that the parties can just agree to amongst themselves. And so if you have heard about antitrust violations where like an MLS tells you you have to pay X amount of money, an LOI doesn't cause that problem because it's A, non-binding, and B, it's an agreement between the parties. It's not a third party imposing restrictions or imposing standards on it. So that problem, we've cut it off at the pass. Beyond that, we have proposed financial terms. So these are the terms that you would like to keep yourself locked into. The buyer would purchase the property, the above described property, for the following purchase price, a number. Here is the earnest money that would be held by somebody, hopefully escrow. If you're still using client trust accounts, you can do that. It's just risky. Balance of the down payment to be paid at closing would be the following amount. Purchase price would be paid in cash, in a loan, and seller financing. If you're going to be paying in cash and that's based on contingent funds, define it. And then the buyer's closing costs, if they're going to be prepaid, they'd be paid in the following amount by the seller. And so you can define those financial terms. This is all proposed. It's not guaranteed. It's not an agreement. It's proposed terms. You're basically saying, hey, I'd like to buy your property. I'm willing to do $250,000. I'd put $50,000 down. What do you think? And if the seller likes it, then you can write that offer. We also have the proposed loan program. This is the various loans that you could use on a transaction like this, and whether the buyer is going to be pre-approved. And if they say yes, then they say, I'm going to attach that pre-approval to the offer. Don't you worry. If you're a buyer and you are pre-approved, please just attach it to the offer. There's no reason to wait beyond that. If in your letter of intent you've already said, I am pre-approved, just attach it to the offer. It's easier that way. And the last thing in this chunk that I'm showing here is the proposed financial representations and proofs. Basically, if the buyer is going to be proceeding with a loan, or if they're going to be providing some kind of proof of cash funds, they're going to have X number of days. In the Oregon Realtors purchase and sale agreements, we do set up a timeline for when the buyer needs to basically show the seller that they have told their lender, I'm moving forward with the loan. You can define that timeline here, or they also have that provision in there that talks about if you're going to be paying in cash, prove you have enough cash by a certain point. And so you can define those timelines here. If it's a deed or title transfer that's going on, then there's a special section for that. If it's going to be seller carried, then define what kind. So note, if it's a deed, that's just whatever. If it's title transfer, you see this little subscript 3, that's for manufactured homes and floating homes. They are title transfers, not deed transfers. And so you aren't going to check that box unless you are dealing with a manufactured or a floating home. And if you're doing seller carried, you're going to define whether it's a promissory note, deed of trust, or a land sale contract. Please note, we don't define this necessarily as an Oregon Realtors purchase and sale agreement or Oregon Realtors deed of trust. You can use the one that escrow provides for the deed of trusts and the land sale or purchase and sale, promissory notes. You don't have to use the Oregon Realtors version. For land sale contract, you really only have the Oregon Realtors version. There isn't one that escrow will typically do. They find it too risky, and so escrow won't write a land sale contract, or title won't do a land sale contract. So you can use your own version. You can have an attorney draft it, whatever it ends up being. You just want to specify, if you're doing seller carried, what kind you're doing. Is it the rent to buy scheme, or is it the purchase equity and then third party holds the deed? You put in a proposed closing date. Note, it's still not binding. So if something happens and you have to move that that closing date before you actually write the purchase and sale offer, make the change. That's fine. This is just a proposed closing date. If life gets in the way, you can make those movements. Now, note, if you do change the purchase and sale, or like the closing date between LOI and purchase and sale agreement, explain that to the other party. This is just kind of a business practice thing. If the seller sees that the closing date has changed, they're going to ask why, more likely than not. And you should just be able to explain it. Hey, turns out the lender says I'm going to need 45 days to get this loan, so 30 days was optimistic. So we're going to set it up for 45 days to closing. Sorry about that on the LOI. Hadn't talked to the lender and fleshed this out fully, but now we know here's the offer. I've already got it figured out. That answer is usually better than just handing them the offer and letting them figure that out. So provide detail. It also has the proposed various equipment that's being transferred, the items and fixtures. The baseline at all times in a purchase and sale contract for real estate is all the fixtures stay with the land and go to the buyer. All the personal property stuff stays with the seller and gets moved off the land. And then you'll specify what's different. Same thing is going to be the case here. You'll find at times for these letter of intent situations, the personal property and the fixtures can be very important to the parties. Things, for example, when you're buying like a farm, if you're buying a farm and you're planning to keep it a going concern, you're buying the business essentially and trying to make it stay a business, you're going to need to buy all the various mill silos and the stuff that comes with that farm, and that's in some cases personal property, not fixtures. There's some weird law that applies where it's like a prune press or drying press that's on wheels is still technically a fixture even though it's on wheels, and so it's sometimes better just to define all that stuff at this stage and say, here's the stuff that stays with the seller, here's the stuff that goes to the buyer, and put it in the LOI at the start because it's something that parties fight about. On the legal hotline, when I first started working at Oregon Realtors, we got a message, a phone call from somebody. The argument was over bird feeders. The question was, they said they got to keep the bird feeders as personal property, but they didn't say they got to keep the spindly metal stick that the bird feeder is placed upon. And now the buyer and the seller are fighting with each other, like to the point where they're almost going to cause a lawsuit over a spindly stick you can get at Walmart for $6. That kind of thing causes problems. So define it in your LOI. The point of this document is to smooth negotiations in the future. Define as much as you can. It makes the negotiations easier into the future when you have all the information at the start point. Next question you have on this one for the non-binding terms, are there tenants? Is the seller going to get rid of those tenants? You'll define that here. Is the property tenant occupied? Is the seller supposed to kick them out before closing? If yes, the seller needs to know that because some sellers don't want to be the bad guy and this could be a break point in the contract. What are the sales contingencies? Does the buyer need to sell their house to buy it? Does the seller need to buy a replacement property first? That's a pretty material term that you'd want to flesh out at this stage. At least let the buyer or the seller know what's going on at this stage. Hey, seller, I want to buy your house, but I do have to sell my house first. Is that a problem? If the answer is yes, then let's just stop here before I even set the offer in front of you. And then you can specify how the home warranty stuff goes. Note, if you don't know some of this stuff, you can just write to be determined or not known yet, or we'll figure out later, or we'll define it at a later date and set that date. You can be as creative as you want with this, but if you don't know this information, it's a negotiation tool. You can leave stuff blank. That's fine. So you can leave chunks of this blank. If you've got a home warranty and you're like, yes, there's going to be a home warranty. What's the plan? Haven't a clue. You can say, don't know yet. It's nice to at least let the seller know we're going to deal with a home warranty in this process, and we'll figure the rest out later. So put as much detail in as you can, but don't worry if you have to leave stuff blank. We do allow the buyer, excuse me, to specify various things that they plan to waive. The buyer should be absolutely honest in this section, because that's the whole purpose of the letter of intent, is to be honest and open about the stuff that's going to make this contract work or not work. The point is not to trick someone. So if the buyer is planning to waive various provisions or release various provisions, specify. So for example, title review period, normally you got that little checkbox. The buyer plans to utilize these things and release all unselected options. So if the buyer is going to be using their title review period, check that box, and you can say how many days you plan to have. The buyer is going to have 10 business days to review the title documents. The buyer is going to take their lead hazard inspection. Great, they have 10 days to complete that inspection. If the buyer doesn't want this thing, not checking the box is an indication to the seller, I'm going to probably waive this. Now, what happens if the buyer doesn't waive it? It's a non-binding provision. It doesn't cause any problems. But if the seller goes into this and they're like, yes, I love this letter of intent, I agree with you because I see that you're not going to do your inspections, and that means a lot to me. And then the buyer comes back and gives them an offer that says, yeah, and I plan on doing my inspections. You have now moved the goalposts on that seller, and the offer might fall apart. So you use this as a way of kind of explaining the terms before you even get there. If you're a buyer and you just are planning to use these things, you check all the boxes. The baseline for a buyer should be, the default should be, check all the boxes if possible. If you aren't planning to use something and you're not certain if you're going to use it, it's like maybe I'm going to do a title review, I don't know if I want to. Check the box anyways. It's better to then say later, hey seller, I'm going to waive this right, rather than to after the fact say, hey seller, remember that thing I wanted to waive? Turns out I actually still want it. It's easier to make the kind of subtractive changes to these forms. It's harder to make additive changes. There are several provisions that provide specific distinct type of property information. This is that grazing timber rights thing that we showed earlier. For example, there's also environmental assessments. If you've got commercial property, phase 1 environmental assessments are going to happen. And if a phase 2 assessment is necessary, here's how many days the buyer is going to have to do that phase 2 assessment. It gets involved when you're doing phase 2 environmental assessments. You have to get, usually it's like engineers and surveyors and environmental specialists to look at the place. And so if you do have to do that, it's going to take time. For number 4, that's agricultural land. It's are you gonna keep your grazing rights, water rights? If there are water rights on the property, is it going to transfer with the sale? Yes, no, that kind of thing. These are specific to your type of form that you're dealing with, the type of transaction that you're selling. The property that you're selling will define which of these you use. Whoa, skip one. Most of the provisions are generally applicable. They won't tell you kind of their limitations. So if it doesn't say anything, it's applicable to all of them. When is the proposed earnest money deposit day? Within 3 business days, within blank number of business days. Every single form, every purchase and sale agreement is going to have a proposed earnest money deadline. Is there going to be a 1031 exchange? Yes, no. I see a question in the chat. So then a letter of intent can be used to establish personal property and other terms as a precursor to the offer. It spells out a lot of stuff ahead of time. How does this work if the document isn't binding? How does it hold up in court if the items or terms are not clearly stated in the actual offer once received? So if the terms are not actually stated in the offer that is received, they are not binding. They're not going to happen. So if on my letter of intent, I say, and I want the refrigerator, and then when I give you the offer, I don't have refrigerator in the personal property, I don't get the refrigerator, because my offer did not include that. I essentially let that fall through in between my letter of intent and the actual offer that I wrote on this sort of thing. Now, what I know, if the seller says, I agree to that letter of intent that I gave you, that means if I ask for the refrigerator, I'll get it. But if I don't put that in my offer, I'm not going to get the refrigerator. That personal property is left behind. Essentially what that means is your letter of intent it's non-binding. This is essentially just used as a tool to negotiate. It's not something you're going to go into court and force somebody to utilize. You aren't going to be able to go to a judge and be like, we signed a letter of intent and it said I got the fridge. And then when I gave them my offer, I forgot to put the fridge. We totally meant the fridge was supposed to be there, as you can see through the letter of intent. So therefore, I should get the fridge, right? The judge will say, no, if you wanted the fridge, you would have written it into your offer. So the letter of intent, it is not meant to be a replacement for your offer. It is meant to simply be a quick version of kind of summarizing the terms before you write the offer. The primary use case for a letter of intent is a commercial or an agricultural transaction where you might have a 60, 70 page purchase agreement, just a ridiculously complex transaction that's going on. That offer takes a long time to write, and it takes a long time to kind of flesh out all the details in a commercial transaction that is going for like a going concern transaction. If that's the case, the parties might want to know if they at least agree on like the main, like the guiding pole lights before they even get to the stage where they're writing a 60-page offer. If you can do it in 3 pages and figure out, is the price right? Is the closing date right? Are the inspections proper? Are they the kind I want? You've figured out many of the possible roadblocks before you even spend the time on writing the 60-page offer that goes to the other party. And so it's not a replacement for the offer. It's a fast track version of negotiating the offer. Keep in mind, if you don't know the answer to any of these terms, leave it blank. It is a sandbox tool. The answer is not chiseled into marble. You don't have to get locked in the non-binding provisions. Leaving a provision blank means you won't be misleading the other party. So for example, if you don't know if you're doing a 1031 exchange or not, I see a comment. Gotcha. Thank you. Is this not something that is generally seen in a residential offer? It is not typical in residential offers, but it can be. It largely depends on the market that you're dealing with. If you've got a buyer favored market, letters of intent are much better because the buyer doesn't want to spend their time putting offers on every single property that they think about and getting counter offers and dealing with that thing. It just kind of depends on the offer, depends on the market, depends on the house. Luxury residential properties, these are more normal. For like run of the mill houses, kind of the middle housing sort of situations, not that common. For a quadplex, which is technically still residential, quadplex, you might see these more often as well because you're dealing with a more complex transaction. Essentially, the more ratcheted up the complexity of a transaction goes, the more useful a letter of intent can be because you've got all the foundational terms figured out before you get into the complexity. And so if something's going to get torpedoed based on a foundational term, that deal is never going to work. If something gets torpedoed based on a complex term, you can usually kind of figure that out and the parties can negotiate around that. So using a letter of intent ensures that you've kind of you've gotten rid of the big problems before you get to the little problems. Where was it? Yeah, so like if you don't know if you're going to do a 1031 exchange or not, don't check the box. Don't say yes or no. If you check yes on buyer intends to do a 1031 exchange, that means something. And the seller is going to be relying on that. If they say, yeah, I agree with this letter of intent, I think this is nice. And if you then get an offer that says something opposite that, then the seller might say, well, this is different from the thing you gave me in letter of intent. If you say no on that section, the buyer does not intend to do a 1031 exchange, same answer. You've given a statement. Theoretically, there should be an NA box that's optional there as well, and that would say the same thing as leaving it blank. In the letter of intent, because it's non-binding, we don't really care if it's filled in or not filled in because it's just informational. It's not super concerning to us if you leave it blank, and we would advise that if you don't know something for sure, leave it blank. Now, the meat and potatoes of the really significant part, the binding provisions. This is more of kind of what parties are going to be dealing with and what you're really locking yourselves into. There aren't very many binding provisions. We'll cover all of them. The core binding provision in the letter of intent is this guy right here, section 31, reasonable efforts. The parties will negotiate in good faith and use reasonable efforts to arrive at a mutually acceptable contract for signature and delivery until such point that this LOI is terminated. Basically, it is an agreement to reasonably work together to try and get something drafted based on the LOI. You're going to work together and you're going to use reasonable efforts. No one here is trying to kind of cheat the other one out of something. This is technically an aspirational provision. It's not something where we can like arrest you or fine you or something like that if you don't use reasonable efforts. How are we going to prove it in the first place? There's really no way to show it. And if a party is not using reasonable efforts, the letter of intent is not going to really kind of cause problems there. But you are theoretically bound to negotiate in good faith. If somebody's using fraud, then this provision does exist as something where you can come in and say they promised to tell the truth and they committed fraud. Now, there's already a lawsuit you can bring for fraud, but this just backs it up and says not only did they commit fraud. They committed malicious fraud because, they're a malfeasant party, not a non-feasant party, because they both committed fraud and they told me they were going to tell the truth. And so that's double bad. They lied and lied again, and that's worse. And so it's technically a protection, but it's not something that we're going to enforce in any significant way unless someone is like openly lying or openly committing fraud. The more relevant provisions are these ones. So for example, the termination provision is binding. If a party doesn't want to give reasonable efforts, they can always just terminate the letter of intent. If the negotiations look like they're breaking down, just terminate the letter of intent. What that essentially means is, and this is my description, it's the legal equivalent of canceling a first date. Nothing has been made official, but you have the decency to let the other party know you're not interested anymore. It's as simple as that. You're not bound under a contract. You're just letting them know, hey, this isn't working out. This letter of intent, I don't like it. I don't like the negotiation. I don't like the terms you're providing. It's just not going to happen. You can just terminate the letter of intent and say, nope, not going to happen. It's not going to work. The letter of intent that we signed earlier, I don't like it anymore. The market has improved dramatically. For example, you're in like a 2008 housing crisis situation where the seller and the buyer had this letter of intent they signed, and then the market just torpedoes and dissolves. And the seller goes, I'd still love to sell the house to you. And the buyer goes, I don't think this is a good deal for me anymore. They can just say, I'm out. This letter of intent, it was good working with you, but it doesn't apply anymore. And so by mutual written consent, you can terminate the contract, or if a party is in breach of the binding provisions, the non-binding party can provide a written statement terminating the LOI and stating that the other party has breached a provision. Now, these provisions are usually something along the lines of like, you're not operating in good faith, or you broke confidentiality. Upon termination, no more obligations. The LOI does not stand for anything anymore. That doesn't mean that if you don't terminate your LOI, you must agree to a contract with the other party. This provision is essentially here for the parties to have kind of a clean exit route so that your files have very clean documentation, rather than the way it sometimes happens where it sort of ends with a whimper rather than a bang. And those situations where the letter of intent just kind of trails off and nobody's really sure what happened with it, that leaves an untied or a loose end in the legal context, and we'd rather you just terminate those things. It also has an expiration date, which basically says, look, if we don't get anything figured out by this point, our LOI is done. We're going to only agree to negotiate or work with this LOI. We're only going to bind ourselves to these prospective terms or to agree to maybe these terms later up to a certain point. If it's 2 years later, I don't care that we have an LOI. It doesn't mean anything to anyone. And so there is an expiration date where we can literally just say this LOI means nothing anymore. Now, again, expiration date, largely aspirational because they're non-binding. It's a non-binding document. So the elements of it, they're like, well, a year ago you agreed to sell me your house for $100,000. If you say that's nice, I now want to sell it to you for $150,000. They can't go, well, but our LOI hadn't expired yet. They can say that, but it's not going to change the fact that the LOI is non-binding. Now, this is the very important provision, confidentiality. It does survive termination. It specifically tells the state in the contract. And this is one of those provisions that is expressly binding and expressly survives termination. If the LOI is terminated, each party agrees they will not retain any documents, work papers, or other material from the other party as a result of or in connection with this letter of intent. And they will not use or disclose any confidential, non-public information in those documents, work papers, or other materials unless required to by law. Neither buyer nor seller may disclose the existence of the status of this LOI or any negotiations to any other party, a party other than seller or buyer's attorney, broker, lender, or advising agent related to the LOI unless required by law. This provision survives termination of the LOI. Basically, once an LOI dies, you don't tell anybody it existed. It's gone. It's done. It's like it never happened. You don't get to tell somebody else, well, I've got this letter of intent I've been working on, so you better put a better offer in. That doesn't work that way. An LOI is meant to be essentially strictly private. It's essentially the same thing as two brokers picking up the phone and talking to each other about possible offers on the property, except it's kind of more put on paper to avoid these kind of potential disclosures of a buyer's negotiation strategies or their information. This is something that is kept fully confidential. And so if you did get documents from the other party, give them back. If you did, if they gave you some well logs or something like that during the course of the negotiation on this letter of intent, give them back. You don't need them anymore if you're a buyer and you're not buying the property. There are a couple other relevant provisions that are significant to a certain extent. Specifically, there's one on brokers. That is, the parties agree and acknowledge that the brokers and real estate agents designated in this LOI have participated in the transaction by acting as an agent for the parties during the negotiation. This is extremely important. It is a very relevant provision for you guys. It basically proves that you were there and you were a witness to this thing and you took part in it and you did your job. So if there is a successful closing, you can say, I was a part of that. I'm entitled to be paid because I helped. The worst case scenario for this broker's provision is a situation where you help a buyer with an LOI for months and months and months on a super complicated transaction or a ridiculously expensive luxury. The Falling Water house is for sale and you're going to buy that thing. Your buyer wants to buy it. And you spend months and months going back and forth with the Frank Lloyd Wright estate and all that stuff. And you finally get this deal that's just pristine. You've been chiseling away at this thing for months and months and months, and it is a masterwork contract, and you have put your lifeblood into it. And then a client fires you before they sign an actual agreement or even get an offer from the buyer, or they send their offer to the seller, and they say, yeah, this isn't going to work out with you anymore. And then miraculously, they sign a contract with a seller that's exactly the masterwork you helped create. This happens where a client fires the agent before the agent has helped put an offer in, even though the agent provided all the baseline contract work that went into the letter of intent. In that case, having a provision in here that says brokers were in this letter of intent, we were part of the transaction, that lets you say, I was a procuring cause. It's a proof that you were a procuring cause to that ultimate successful closing, and it means you're entitled to a commission. Without this provision, you can still get a commission out of a letter of intent that you've helped negotiate the successful end result, but it's more difficult because you have to prove essentially that very tenuous dotted line that says I was an agent on the LOI, then LOI led to sales agreement, then sales agreement led to successful closing, and therefore I was a part of all of this. It's much more difficult to prove if you don't have a provision that says, hey, heads up, I was here, I was an agent to it. If your name is never on the LOI, it's your word against the clients, and sometimes clients lie, and that makes for a very interesting lawsuit, and we don't want to deal with that. So your name is on the document, and you are essentially a party that is entitled to commission if you are part of a successful close that involves the LOI that you worked through. The other provisions on this one, costs. The buyer and seller will pay for their own respective costs and expenses incurred in connection with the LOI. This includes, but is not limited to, attorney review, professional services, advisory fees. This will survive termination of the LOI. So if the buyer wants to hire an attorney to talk this stuff over, buyer pays for their own attorney. Now, the parties can disagree with this and they can change it with a general addendum, say, actually, seller is paying for buyer's attorney, but no one usually does that. But essentially, if you're hiring people to help you kind of work this thing out for the more complicated transactions, this sometimes happens. For example, if you've got property that has like a famous mural on the wall of some building in Portland or something like that, when you're buying that building with the mural on it, you might have a VARA issue where you've got the Visual Artists' Rights Act, and you're going to want to have a lawyer work through that process, because if you don't and you want to get rid of the mural, let's say it's something you don't agree with, it's I don't know, a mural that says something that you find reprehensible, at that point you shouldn't remove the mural without the artist's permission, and if you do remove it without the artist's permission, you can get fined or sued for up to, I think it's $150,000 per violation. So like a lot of money. You want a lawyer to help you through that VARA claim. We're not going to say that we're going to split the costs between the buyer and the seller when a lawyer gets involved to help with the letter of intent. When you hire a lawyer, you pay for your own lawyer. That's what this provision says for its costs. And then Section 35 it's not required, but it is in the binding provisions because it is a reflection of binding federal law. You gotta be non-discriminatory in your letters of intent. The parties agree and acknowledge that it is illegal for either party to refuse to display, lease, or sell the property to any person on a basis of race, color, national origin, religion, gender, familial status, disability, marital status, or source of income. Your cities might have additional ones. I believe it's Corvallis that has ethnicity and religious background or religious practices. So cities might have more than just this, but you agree to comply with federal, state, and local fair housing laws. What this basically means is you can't use the LOI as a Trojan horse to get around the fair housing laws. You have to still follow fair housing. So if you're in a letter of intent and you get halfway through and then the seller, for example, goes, I don't want to sell this house to that person because they're black, that's still a fair housing violation. It's not just because it's an LOI doesn't mean you're scot-free on that sort of situation. at the very, very tail end of this document. It's technically in the binding provisions section, but it's underneath all the signatures. There is this section that says this LOI was presented on a date at blank time by the following agent and the agent's signature will be put on that. This is not actually required. You don't have to sign and date the document, but you should. As an agent, it's better for you to do this. Basically, the agent has an obligation to present all offers that they receive as well as all written communications. This is under ORS 696-805, the buyer's duties, agent duties, and 810, which is the seller's agent's duties. As an agent of a buyer or a seller, you have an obligation to present these written communications to your client. If you ever get investigated by OREA, you have to be able to prove that you presented communications to your client. Usually it's as easy as showing them the email, but having something on the document that says, I presented it on this day and I signed it, that's more helpful. It's just another thing for the file to back up the fact that you're doing your job. And it makes it harder for kind of OREA to prove that you did your job incorrectly if you've got this provision and it's been used properly. So that's there to protect you guys and your practice. As far as the letter of intent goes, if the parties don't have certain information figured out, again, reiterating, leave that provision blank. If things change, talk to the other side. This is a negotiation. Sometimes things will change and that'll torpedo the transaction, and sometimes they won't. When the offer purchase price is different from the LOI's purchase price, you might see the transaction die. The LOA might just not work because the seller went into it expecting to make $250,000 and you're only offering $200,000. That's enough that a seller might say, yeah, this is not going to work. For other things, the parties might be able to wheel and deal with it. If the buyer comes back and says, hey, turns out I can't close on the day I was supposed to, I can close a week later. Are you still okay with that? The seller might say, yeah, whatever. The LOI said August 5th. I don't care that it's now August 12th. I'm still selling my house. That's lovely. So be aware if there are changes, still talk to the other party, describe the changes, tell them about it, but don't be super concerned about trying to keep that information close to the chest because it's something that will pop out when you put your offer down. And so it's better to kind of talk those things out and hash it out at the start point rather than to put the offer down and let the seller kind of wallow in the uncertainty before the offer is accepted or rejected. An LOI is not necessary in every transaction. Please be aware. It is a tool for use by the parties if they want to use that tool. They don't have to. It is an optional addition to the contract if you need it. It's not something that has to be there every time. Depending on how sophisticated your client is, they might have LOIs that they've used in the past that are more binding or less binding, and this could cause confusions. Occasionally, a client might be more familiar with like a lawyer-drafted letter of intent, which typically has many more binding provisions and locks parties into things with a much greater degree of depth. If that's the case, your client might want that kind of hyper binding letter of intent because that's what they're comfortable with. We don't necessarily, we're not the Oregon Realtors Forum and group and the Realtors Forum creators and the lawyers and all that. We don't think that this letter of intent should be used in every transaction. It is a tool to help you if you need it. If your client doesn't want the tool, don't use the tool. So just be aware it is something for you to use if you need it, but it is not something that has to be utilized every single time. And that's what I've got on letters of intent. If you have other questions or comments, we have a forms hotline that you can call where you can ask us questions about the various forms and how to use them. That's 503-587-8884. It's the same hours as Oregon Realtors office, 8 to 5. We also have forms at OregonRealtors.org, which is a way that you can email any kind of comments or updates or questions about the forms. You can send it there. It is also worth noting, as a realtor in the state of Oregon who pays dues, you now have access to the legal hotline as well. So legal@OregonRealtors.org. You can shoot an email to that and the legal department, which most days I'm the legal hotline. We will answer your questions about various elements of your transaction. This is stuff where you're like, hey, my seller says they buried a body on the property. What do I do? You can call us up and ask those questions, and we can provide answers to you on kind of how to interpret the forms, how to interpret the contracts, how contract law works, how agency law works, how business law works. We're not going to write your will for you. We aren't going to help you kind of navigate your messy divorce. That kind of thing is not going to be what we do, but we will help you with various elements of your practice for the professional real estate area. And so if you send an email to legal@OregonRealtors.org, we can help with providing kind of feedback and legal advising on your transactions. If it's your first time ever sending a message to the legal hotline, be aware we will have you sign a memorandum of understanding, which basically says we're not your lawyer. If you do have to go to court, you're going to have to hire a lawyer of your own. We're not going to be there representing you. That memorandum of understanding is largely there because we have 19,000 members statewide, and no lawyer in America has 19,000 clients. It's just not something they can do. And so in order to be able to kind of offer the service up to the number of people that we do, we cannot be your actual attorney. We provide advisory, kind of very specialized and very knowledgeable advisory opinions, but they are advisory opinions. And that's what Legal Hotline is for. And with that, that's what I've got for you. If there are questions, I'll stay on for a while and you can post them in the chat. If you've got Legal Hotline questions, have at it. I'm here. Otherwise, this is our 50 minutes that we need to put in to get CE, so we check that box. If you're interested in having a straight, like face-to-face interface with an attorney and just ask questions, kind of like a way to interface and just talk about various elements of transactions and forms and things like that, on our orforms.org website, we have a link to a open house that we do every week on Fridays from 11 to 12. The legal affairs director, Jeremy Rogers, will be on for this one this week. And so if you want to ask him about like upcoming legislative pushes that we're going to make, he can help you with that. Everybody have a wonderful weekend otherwise. Enjoy the weather. Oh, thank you for that, Katie. Katie posted up the legal hotline or the open house link in the chat. So if you are curious about the open house, that's the link.